You know, sometimes a simple disagreement in a neighborhood can spiral into something way bigger. That's exactly what we're looking at today. It's the story of one homeowner who went head-to-head with his homeowners association, and the entire fight boiled down to the definition of a single object in his backyard.
And this is the question, right here. This is what the entire case hangs on. It seems so simple, right? But believe me, how you answer this question changes everything. Is it just a harmless little shed for storage, or is it a vehicle that's breaking the rules?
So it all starts with a guy named David Iadevavia, a retired astronomy professor. He gets a violation notice from his HOA, the Ventana Shadows Homeowners Association. And it's about this thing on his property that they're calling a mobile observatory.
Now, the HOA didn't just pull this out of thin air. They pointed to a very specific rule in their governing documents, Section 2.16. Their argument was that his observatory was, for all intents and purposes, a trailer, and he was storing it out in the open, which was a big no-no. And just in case you're not familiar, CC&Rs are basically the rule book for the whole neighborhood. Think of it like the community's own private constitution. When you move in, you agree to follow these rules, which is why a violation notice like this is a really big deal.
So what could have been a pretty straightforward issue, pay a fine, maybe move the thing, it escalated fast. The fight moved out of the neighborhood and straight into the formal administrative legal system, and that's where things always get a lot more complicated.
And just look at this timeline. It shows you how quickly everything went down. Legal orders are flying back and forth within a matter of weeks. But then, look at that last one. On June 6th, just a few days before a super important conference, Iadevavavia's lawyers just bailed, leaving him to figure this all out completely on his own. Okay, so a pre-hearing conference is supposed to make things simpler, right? Iron out the issues before the real hearing. Well, in this case, it did the opposite. It actually uncovered a huge and very expensive mistake in how he had filed his complaint in the first place. See, he had paid a $500 filing fee. That fee lets you argue one single violation. The problem? He had actually listed 3 different violations in his complaint. And this is where that fee problem really comes back to bite him. He wanted to argue about the trailer rule, that he got an improper notice, and that they violated open meeting laws. But because he only paid for one issue, he was forced, right then and there, to pick just one. He chose to fight on the trailer rule, Section 2.16, and that's where he ran smack into a brick wall. And boom! This quote from the judge says it all. He was arguing that the HOA violated a rule, but the rule he picked is one only a homeowner can violate. It's a rule for residents, not the association. The HOA is the one that enforces the rule. They can't technically break it. His whole argument was pointed in the wrong direction. So the judge, seeing this major flaw, actually stepped in and amended the official issue. The case wasn't going to be about whether the HOA broke a rule anymore. Instead, it would be about whether they were applying the rule unfairly, picking on him while letting other people get away with similar things. This gave him a brand new and actually workable argument. All right, so that brings us to the main event, the hearing itself. This was his big chance, representing himself to prove that the HOA wasn't just enforcing its rules, it was singling him out. And his strategy was pretty smart, actually. It was all visual. He just started showing a bunch of pictures of other backyard structures from all over the neighborhood. He was arguing, hey, look at all these sheds. They're visible over the fences, but none of these people got a violation notice. And he had a bunch of examples, regular storage sheds, lean-to structures, you name it. But here's the kicker. He had photos of sheds on the property of the HOA's own vice president and president. His point was crystal clear. If all these are okay, why is mine such a problem? But, of course, the HOA's lawyer was ready. The lawyer starts a cross-examination to just systematically tear down his whole comparison. The goal was to prove that his mobile observatory wasn't a shed at all. It was something else entirely. And they just started listing off the features. It has a license plate, it has axles, it has wheels. I mean, these aren't things you find on a backyard shed, right? They're the defining features of a vehicle, of a trailer. That was the core of their entire argument. And then, this was the moment, the knockout punch. A board member for the HOA gets up to testify and points the court to Iadavia's own website. And right there, for everyone to see, were pictures of his observatory, not as a shed, but as a full-on mobile trailer with, in their words, wheels ready to roll. He was undone by his own evidence.
So after all the evidence was in, it all came down to the final arguments. Both sides had to make their final pitch to the judge and convince her that their interpretation of the facts and the rules was the right one. And this slide really breaks down the legal heart of the whole thing. Iadevavia's side said, look, the word trailer isn't even defined in the rules. That means the HOA can just apply it however it wants, and that's not fair. The HOA's response? Come on, some words don't need a definition. Everyone knows what a trailer is, and his thing is a trailer, period.
Okay, so let's zoom out from this one specific fight. What can we all learn from this case? Well, it actually offers some really powerful lessons for anyone who lives in a neighborhood with an HOA.
First off, definitions are everything. The entire case can hinge on a single word. Second, the legal process is super rigid. It doesn't care if you made a simple mistake, like paying the wrong filing fee. Third, you've got to know the exact legal basis for your argument or you'll end up fighting a battle you literally can't win. And finally, representing yourself against professional lawyers is an uphill battle to say the least.
And here's a little update for you. It's kind of ironic, but by the time the actual hearing happens, Iadevavia had already fixed the problem. He built a wooden screen around the observatory, hiding it from view. So even while they were fighting over the legal principle, the real-world violation was already gone. And that really brings us to the final big question. This whole thing boils down to a fight over interpretation. So it leaves you wondering, when a rule is vague, who really has the final say? The person trying to follow it or the organization that gets to enforce it?